good. All right. I got the thumbs up that it's working correctly. So it's 12:01, and so I think we're going to go ahead and get started. Other people may join here shortly, but we'll just keep going. So this presentation is going to be on non-compete law changes that recently happened in Colorado and recently became effective on August 10th, in fact, and kind of going over what Colorado entrepreneurs need to know about this new law and how you're going to deal with it in the future. So let's go ahead and get started. First slide here, just a biography. This is me, co-founder of Attorney Crow Legal. We're a boutique corporate law firm, and we focus on helping entrepreneurs grow, finance, and sell their businesses. And most of our clients are entrepreneurs in some fashion, whether they're fund managers, whether they're starting a new startup entity, whether they're looking to raise money, they're doing a syndicated real estate deal, or anything like that. Is kind of what our firm focuses on. So that's just a little background on us, but let's go ahead and get into the meat and potatoes here of this new law. So here's the agenda that we're going to go over. First, I'm going to give just a quick summary of the new law, then go over the main highlights that I think are most important to entrepreneurs to know. And then those include, what are those exceptions to the prohibition on non-compete agreements? We'll talk about non-solicitation agreements. We'll talk about confidentiality agreements. We'll talk about these new notification requirements that's required under the new law. And then we'll talk about the new penalties that are out there for somebody trying to enforce a invalid non-compete under the new law. Then kind of a takeaway section, a lot of repeat of what are these main highlights, but also with some tips on what entrepreneurs can do next. And then we're going to open it up for Q&A. I think the best way for Q&A is going to be to type your question in the chat function, and I'll try to answer those as they come. All right. So here's the statutory section here, CRS 82113. So that has been the law governing non-competes for a long time. But in May of this year, the Colorado legislatures passed this law that made significant changes to this section, which again was a longstanding statute in Colorado that governed non-competes. And Jared Polis, the governor, signed this bill into law on June 8th, 2022, and it just became effective on August 10th, 2022. So, in application of this law, I mean, this law applies to all Colorado employers and any business that employs a person who primarily lives and works in Colorado. So it could be a Kansas company that has employees in Colorado. Well, this new law is going to apply to them, those employees that live in Colorado, live and work in Colorado. Now, to kind of understand this changes here, I think we have to go back a little bit and understand what the old law said. And again, it was still under this section, this statutory section here. And basically, the prior law said that a covenant not to compete, which is something that restricts a person's right to receive compensation for the performance of labor or services, whether it's skilled or unskilled. It basically said that those are void as a general rule with certain exceptions. So that's what the old law said. And with the new law, the default rule still remains that in Colorado, it says that non-competition agreements are unenforceable unless you meet certain exceptions. And it's the company or the employer's duty to show that certain exception applies in order for that restrictive covenant to be valid, right? And by the way, I use the term restrictive covenant, and that's just kind of a fancy legal term, I think, for an agreement that restricts somebody from doing something. So when I say restrictive covenant, it's just an agreement where somebody has restrictions on what they can do. So any non-competition agreement, non-solicitation type agreement, those are all restrictive covenants, which are really just a provision in an agreement. So it could be an employment agreement, for example, that covers a bunch of different areas, but it has a restrictive covenant in there, which is the non-compete or non-solicitation. So hopefully that doesn't confuse anybody. The restrictive covenant is just really any portion of an agreement or any agreement in itself that restricts somebody from getting compensated for labor services. So, while this concept of the general prohibition on non-competes with certain exceptions remains the same, the applicable exceptions and how you comply with those exceptions has changed drastically. So that's what we're going to be talking about today. Some of the old exceptions, just so we kind of cover that, what the old law said before this new law changed it. It said that you could have a non-compete agreement, or it was per se unenforceable unless it fell into these exceptions. And some of those exceptions were a contract for the purchase and sale of a business, whether it be the equity in that business or the assets of that business. Any contract for the protection of trade secrets was also enforceable. And any contract for the recovery of certain expenses for training costs for employees who only stayed with the employer for less than 2 years. And then there was also this exception that was for executive and management personnel and officers and employees who constitute professional staff of the company. And so that was kind of this catch-all that a lot of employers hung their hat on, was this executive and management personnel provision that said you could have a non-compete and it was enforceable for those people. And it was used often, as that being the reason why this non-compete was enforceable. The sale of the business exception still remains. So the new law hasn't changed that. So you can always have a non-compete in the sale of a business type context. The training cost recovery has stayed the same. You can still recover training costs for employees who work for less than 2 years if you spent significant amounts on training for that employee. Now, the new law did revise that a little bit, and it clarifies that recovery must be only on training that's distinct from normal on-the-job training. And it also said that it has to decrease proportionally over the number of months they work. So over the 2-year period, if you spent $5,000 on somebody, it has to proportionally decrease on the amount that you can recover over a 2-year period. So if they leave, on month 23, you're only collecting or can only recover 1/24 of that training cost that you expended. And then there's doctor-specific exceptions in the law that really haven't changed. Really those, I don't deal with those very much, but in essence, they say that it voids non-competes for physicians, although it does allow for the recovery of damages, which is kind of a weird concept that you can't prohibit somebody. In other words, you can't have an injunctive action that really stops somebody from a physician from going to work for somebody else, but you can recover damages from them if you have some provision in there about collecting damages for them, going and competing with, a prior business that physician worked for. Now, there are certain exceptions for doctors that treat rare disorders. So that's another exception. But again, we're not going to get into those specific physician-related non-compete provisions. And then note, even if a non-compete exception applies, so the courts have added to the law by saying that any non-compete, even if it is valid, in other words, it fits into one of those exceptions, that it requires that non-compete to be reasonable in time and geographic scope for it to be enforceable. So, even if you had a sale, for example, a sale of a business non-compete, if you made it unreasonable in geographic scope or time period, then the courts could step in and say, oh, that's not enforceable. And so some of that actually in the new law gets added into the law itself rather than it being a court-made addition to the law. One of the major changes and one of the biggest changes in my mind is that it imposes an income-based minimum on enforceable non-compete agreements with employees. And so we'll get into that in more detail later in the slides. And then I wanted to note, how does Colorado stack up against other states out there? And so, Colorado, this new law, I believe, puts Colorado as among the several states, probably about 10 out there that have adopted similar laws as some of the most strict when it comes to non-compete provisions or prohibiting non-compete provisions. So Colorado is now one of the one of the states out there with the most restrictions on employers having non-compete agreements. All right, so let's talk about the main highlights here, or the exceptions. And so I'm really not really gonna focus on purchase and sale of business, even though that's in here, and not really gonna focus on the training cost recovery, although that was modified by the new law. I kind of already mentioned that, which is the recovery period has to be over the 2-year period. It has to get reduced, or the amount you can recover has to be reduced over that 2-year period. Sorry, my lights keep going off in here. So the focus is on this highly compensated employees for the protection of trade secrets. So it removes that exception. The new law removes the exception for executives and management personnel and their professional staff. So that's no longer something that employers can hang their hat on when entering into a non-compete. And what it says now is to allow the non-compete to be enforceable, it has to be for employees who are highly compensated. So the current threshold for that is $101,250. And so the employee has to make at least that much for the non-compete to be enforceable. And it's also, in addition to them being highly compensated, the non-compete has to be for the protection of trade secrets. So it kind of combines those two prior exceptions to say that not only do they have to be highly compensated now, they also have to, it has to be for protection of trade secrets. And then the statute went on to say that the protection can be no broader than is reasonably necessary to protect the employer's legitimate interest in protecting trade secrets. So that added piece there, I think, is going to be hotly debated and potentially litigated in the future on what exactly the scope of protection of trade secrets is, and how far you can go with that. So anyway, this is a huge change, and something that people need to be aware of is that if you're going to have a non-compete agreement for an employee, they have to be, and it's not just a cost recovery, and it's not a purchase and sale of business type situation. Then it has to be a highly compensated employee, and we'll get into a little bit more about what that is. And I know there's questions about what does that mean to be highly compensated. We have a number here of $101,250, but what if they're a salesperson, right? And they get commission, so their base may be below that, but they make more than that, typically with commissions. And so those sort of questions are out there, and the way that it's addressed in the statute and in some of the commentary is that it's annualized compensation. So all expected compensation for the year. And so again, does that include health insurance? Does that include benefits, things like that? I think, my broad interpretation is that it arguably does, because it says any sort of compensation that somebody can get over an annualized period. And so arguably it includes those type items. There's also the commission question. What if they get a lower base, but they have commission? Well, the commentary is out there now has been that if they historically have made that and have a reasonable likelihood that they're going to make that in each year, then that's going to be something that's enforceable. So, but note that this has to be, they have to be highly compensated at the time they enter into the agreement and at the time that you enforce it. So, when you enter into the non-compete, it can't be that they made, a lower amount and then later they ended up entering into that highly compensated employee arena. They have to have it both when they sign the agreement and when they're terminated. So again, if somebody, gets a demotion or maybe sales commissions go down and it doesn't, for the past 3 years, they haven't made over that threshold, then it's likely not enforceable anymore to that person. All right. So that's a big one. Non-solicitation. So this is now specifically addressed in the new law, and previously it wasn't really addressed. But although courts had said that a customer non-solicitation was treated as a non-compete agreement. So, courts had put it in, and now the statute specifically says that these are addressed. But I do want to point out there's a difference in here between customer non-solicitation and employee non-solicitation, right? So a customer non-solicitation would be a situation where you have a provision in an agreement that says you can't go and solicit any of the customers, because one of the biggest trade secrets a lot of companies have is their customer list, right? And contact information. And, courts have long upheld that if somebody is an employee at a company and they walk out with the customer list and contact information and, set up shop across the street and start smiling and dialing those customers, they've misappropriated trade secrets. And so that is specifically addressed and permitted in the new law, and they give a lower threshold for that. So the lower threshold for non-solicitation, customer non-solicitation, is 60% of the highly compensated threshold amount. So that's currently $60,750 is what somebody needs to make. And so you can have these customer non-solicitation agreements even for the lower wage workers. Anybody who's 60,000 and above, depending on what you consider lower wage workers, but at least lower than this highly compensated threshold that applies to just a general non-compete. And in addition to that customer non-solicitation, it also has to be no broader than reasonably necessary to protect the employer's legitimate interest in protecting trade secrets. So it still has that requirement that if you have a customer non-solicitation agreement and it's enforceable because it's with an employee who at the time of entering into the agreement and at the time of enforcing it has made over $60,000, $750 or whatever. Employee non-solicitation, those are those type of agreements that say you can't come and try to solicit employees once you leave. If you leave, you can't come back and say, all right, I'm going to solicit all these employees to work for a new business that I'm starting. That has been untouched by the law. And so those both, statutorily and courts have treated those separately from, the statute section 82113. And so those weren't addressed by this new law. And so, the General Assembly in their notes talked about this being preserved as with the existing case law. So in general, the employee non-solicitation agreements that you have out there are not going to be affected by this new law. And those are still enforceable and as long as they're reasonable and can be, put into agreements. All right, let's go into confidentiality agreements. So this is also under confidentiality provisions are being addressed with the new law for the first time. And so basically this says that confidentiality agreements are enforceable as long as they don't try to protect information that arises from the worker's general training, knowledge, skill, or experience. And it's whether it's gained on the job or otherwise, or information that's readily ascertainable to the public, or information that the worker otherwise has a right to disclose legally as protected conduct. So it's really my takeaway. One of the takeaways I'm getting from this law is that I think that the legislature is trying to put people into entering into confidentiality agreements as opposed to straight non-competes, to say, hey, you can protect confidentiality of certain information, protected information that it's truly secret, not something that's just general knowledge that someone would get by working at your company, and something that is not readily ascertainable by the public. That's how you can protect a lot of intellectual property, trade secrets, and things like that with this confidentiality agreements. All right. I think, but going back to this confidentiality agreement I cannot see the chat. Sounds like there's something in the chat. Let's take a look. Let's see here. Chat. How does this apply to veterinarians? That's a good question. I think to veterinarians, it applies the same as it does to anyone else. I think I would have to look into that a little bit closer. I don't know if those physician exceptions apply to veterinarians or not. Honestly, that's something I would have to look up. So I'm not sure if they don't. If they're considered just like physicians are, then there would be then there's a specific prohibition against non-competes, except for the fact that you can go after them for damages if they compete, unless it was a rare disorder. And I imagine that rare disorder is limited to humans, but I'm not 100% sure on that. All right, what's the next one? How about a new hire that made that kind of money at previous employer? So I'm not exactly sure where, if I'm going to be answering that question correctly, but I think it really looks at what they're going to be paid at this job. So for example, if they were making, $150,000 at a previous employer, and then they come to work for your company and they're going to be making $90,000 all in annualized salary, then I don't think it's enforceable. So that the prior employer is not going to work. Now, I do think that it may be an important fact if you're saying, hey, this person was a salesperson at a similar company before, and now they're coming here to be a salesperson. They've closed this many deals, which under our pay structure is going to, put them over that threshold of a highly compensated employer amount. Then you may have a reasonable basis to enter into a non-compete with them, because you're saying that even though their base may be below the threshold, it's highly likely that they're going to make over that threshold when you do all in annualized salary with their commission and things like that. All right, next one. Can you expand on reasonable terms? Do Colorado courts redline unreasonable terms? Yeah, so very good question there, Kyle. They have, so what happens in a lot of contracts is there's kind of a blue pencil. There's this thing called the blue pencil doctrine, right? And what it says is if you do have an unreasonable in geographic scope or in time, or maybe overly broad provision that's not reasonably, that's not specifically tailored to the protection of specific trade secrets for a company, well, can you have a savings provision in there, like a blue pencil doctrine provision that says, hey, to the extent that this is overly broad or unenforceable, the parties agree that this agreement will still be in effect, but it will be reduced to whatever is reasonable in the eyes of the courts. You're playing judge roulette with that one, because some courts have gone ahead and said it's yes, we're going to take that use the blue pencil doctrine, is what it's colloquially called, to kind of take those terms and make it reasonable so it is enforceable, right? So we're just going to reduce the scope of this and say, whatever is reasonable is what we're going to apply here, and that is enforceable. And then other courts, judges in courts have said, nope, it's invalid and unenforceable at this point. So there's not a clear answer to that question. Unfortunately, I think you're kind of depends on which judge you get, and sometimes what maybe mood they're in, or how good the attorneys argue it from both sides. But that's going to be a question up there. I think what the main takeaway from that is that the safest route is to really take the time and try to make sure that whatever you do write in that agreement is narrowly tailored and enforceable from the outset. That you're making sure that it's only a legitimate protection of trade secrets. And I know that's easier said than done in practicality, because businesses are changing every day. You may be going into new areas, starting new lines of business, things like that. So it's hard you want to be broad, but at the same time, you don't want to be overly broad, because then you run the risk of a judge coming in later and saying that's unenforceable. All right, let's see here. Go back to the slides here. All right, so confidentiality. I think we, oh, I think, what I was getting at there, and I don't think I got to or said, was that I think the standard for confidentiality agreements is going to be a litigated item too. That it just, the way that it's worded, it's kind of a little bit too squishy, I guess, for lack of a better term. And it's going to allow, there's going to be arguments on both sides of whether, this information was just normal knowledge, skill, and experience gained on the job, or whether it was public information or not. And that sort of thing is going to be up for debate when you're on the edges, right? So there's going to be, I think, there's going to be very clear situations where it's obviously public information, and there's going to be very clear situations where this is very confidential to the company, and they keep it confidential, and they take steps to protect this information, and somebody takes it. That's going to be very clear on one side, and then there's going to be clear on the other side with things that are obviously public information or normal on the job type training. And then there's going to be a lot of stuff in the middle that unfortunately is going to probably have to go to litigation to determine. And it's really going to be kind of a facts and circumstances type test in my mind, for each particular company, which is, again, that makes it harder to comply with. All right. Next thing is this notification requirement. So this one, I think, is the biggest takeaway you can take from this presentation, is this new notification requirement. And this is going to be the one, I think, that most people miss and most people fail on, because it's just adds an extra layer of burden to employers who are already, busy and trying to, get everything done in a day. And now this is an added requirement for the intake process for workers. So, this one, I think is going to be often missed, and it's going to be to the detriment of employers that have otherwise valid restrictive covenants to not compete, right? And so what this new notification requirement says is that, an otherwise valid restrictive covenant, so meaning that, it otherwise complies to one of the exceptions, and it's enforceable, that it's going to be considered unenforceable unless the employer provides sufficient notice of the restriction. And that requires that in the case of prospective workers, that they receive this notice of the restrictive covenant prior to acceptance of the offer of employment. So you can't, give them the offer of employment and include in the packet of papers to sign a non-compete. It's saying you have to give them prior notice of that, of this non-compete restrictive covenant. And for current workers, if you have a current worker that maybe now meets the highly compensated threshold, you have to give them notice at least 14 days before the effective date of the non-compete agreement, or 14 days before any additional compensation or consideration is provided to that worker. So a lot of times, to get somebody to sign a non-compete, you want to have consideration for that, right? So you want to say, hey, we're going to give you something, and in exchange, you're going to agree to this non-compete. And that might be a raise, it might be, a bonus, it might be, promotion, anything, something like that. And so they have to receive it 14 days before they receive that additional compensation or consideration. And lastly, and the most important provision, which I didn't put on this slide and I should have, is that the notice must be in writing, and it must be signed by the worker in a separate document. And so basically you can't just rely on the fact that, hey, I sent him an email with the provision and said, hey, there's a non-compete provision in this. It has to be a separate notification where it says, hey, I'm going to send you this agreement, a copy of the agreement that has a restrictive covenant provision, and it clearly identifies where that is in the agreement. Like I said, it could be in a big employment agreement, and it's just one section of that has the non-compete provision. Or it could be just a separate non-compete agreement, right, where it's easier to point out where it is. But they have to sign that. And it has to be signed prior to acceptance of the offer of employment for a prospective worker, and it has to be signed 14 days before the effective date for a current worker, or 14 days before the additional compensation or consideration is provided to that worker, if it's a current worker. So that is the piece that I think is going to get overlooked and is very important for people to understand and to implement. And so it's going to take, training on your intake team, employee intake team or HR team, whoever's in charge of that process needs to build this in to their process to make sure that they have, that they're getting this. If you're trying to have enforceable non-compete provisions, non-solicitation provisions, anything like that, you want to make sure that this notice is being provided early, and it's in a separately signed document. That separately signed document just needs to say that they acknowledge that worker, current worker, prospective worker acknowledges that they've received a copy of the agreement that has the restrictive covenant and that has the date on it, right? So that's going to be the important piece of it. All right. Next, to add to all of this, we have civil and criminal penalties that could apply. Let me see. I just want to make sure there's nothing in the chat here. Okay, nothing yet. So civil and criminal penalties now.
Sound.
Employer, if you present a worker or prospective worker with a non-competition agreement that is void, so it's not enforceable under the terms of the new law, or who enters into a void non-competition agreement, or an employer who even attempts to enforce a void non-competition agreement can be liable for the actual damages that person incurs, which also could include a penalty of $5,000 per worker or prospective worker harmed by the conduct. And in addition, the court can issue or can award injunctive relief, and the worker or prospective worker may recover actual damages, reasonable costs, attorney's fees in a private right of action. So the $5,000 per worker, prospective worker could be brought by the state, or could also or could be a private right of action that the worker that was harmed brings, and in that case, the worker would get to recover actual damages plus reasonable attorney's fees and costs in bringing that action. So there's civil penalties that can apply to employers here if they're trying to enforce or trying to get people to enter into invalid non-compete agreements. There's also criminal penalties, and the criminal penalties say that it can be a class 2 misdemeanor if anyone uses force, threats, or means of intimidation to prevent any person from engaging in a lawful occupation. So note that this criminal penalties only applies to the enforcement. So you're not going to get, if you have somebody enter into an invalid non-compete, you may be subject to, but you don't try to enforce it, you could be subject to civil penalties. But you would only be subject to the criminal penalties if you tried to enforce that invalid non-compete. And you did it through the use of force, threats, or other means of intimidation. Now, again, that is going to be an issue, because what is considered a threat or not, I think, is going to be a tough one to determine, and that could be litigated. But a class 2 misdemeanor, that could mean class 2 misdemeanors in Colorado have penalties of up to 120 days in jail, or a $750 fine, or both. And so that's, it's something that you want to be aware of. Now, in the Legislative Council's staff, notes on this law when they were reviewing it, there's a bunch of legislative notes and history that goes into a bill before it gets passed. And in reading through that, there was a note about this, and said that there's been 0 offenders that were sentenced or convicted in recent years for a criminal penalty under this statute, because this criminal penalty had existed prior. It just wasn't clear in the statute, which was now changed with the new law. But they said nobody has been convicted in recent years, and so they assumed that there's going to be minimal or no additional criminal case filings or convictions under the new law. So, I don't think this is something that necessarily the state is going to try to enforce too much on the criminal side, but it is there and something to be aware of. Let's see here. Yeah, okay. So there is a silver lining. The only silver lining, I guess, when it comes to the penalties provision is that the new law expressly adds in a provision that grants courts the discretion not to award penalty or to award less of a penalty if the employer shows that it acted in good faith and had a reasonable grounds in believing it was not acting in violation of the statute. So that's important, I think. And that's both, that's on the any of these penalties side. If you can show that you were acting in good faith and you had a reasonable grounds to believe that you were not acting in violation of the statute, then the court has discretion to say, all right, well, we're not going to award penalties here, or we're going to award less penalties. Maybe we don't award attorney's fees to the plaintiff in this case, something like that. So the court certainly has discretion on the penalty side. All right, takeaways. So some of the big takeaways here are these big ones, and we've kind of addressed them, but I'll kind of run through them one more time here. Choice of law and forum provisions. So this applies a lot to multi-state employers who are, you got that Kansas City employer that has a Denver office. A lot of times what those Kansas City employers did was have a non-competition agreement, and they said that the choice of law was governed by, Kansas or Missouri law, for example, and the choice of forum was in Kansas, the courts in Kansas City, for example. And so they would have a provision in the agreement that said that. And previously that could have been enforceable. And so that worker who resides and mainly lives in this new law says that that's not going to fly anymore, right? So it says if the worker primarily lives and works in Colorado at the time, and this is at the time of termination. So it could be, that they were in some state before and then they move. But if they move to a new state and move to Colorado at the time of termination, then the restrictive covenant must be governed by Colorado law, and it can only be enforced in Colorado. So they can't force you to go to another state to as a forum, and they can't have that to be the choice of law provision. It has to be Colorado law and has to be in a Colorado court. So particularly for multi-state employers, this is an important provision to take a look at and make sure that you don't have just a one-size-fits-all non-compete agreement or employment agreement that says, everything's governed under Delaware law and be enforced on in Delaware courts or something like that, because it's not going to work in Colorado. Trade secret protection. So this is the provision, the new law that says that it has to be reasonable for protection of trade secrets, and that it's only enforceable against highly compensated individuals. So, the old reliance on this management and executive personnel provision that was there in the old law is no longer there. So you can't use that provision unless it's for the protection of trade secrets and it's for a highly compensated individual. So that's important. Non-solicitation. So we kind of went through that, the employee non-solicitation versus customer non-solicitation. And so remember with non-solicitations, you can have customer non-solicitation agreements and the threshold is lower. It's only 60% of the highly compensated individual provision. And so those making currently the law set with those making 60,000 and above can be subject to a customer non-solicit agreement, provided that it's reasonable in scope for the protection of trade secrets, right? And so they give you a little bit of leeway there on customer non-solicits. And then the employer non-solicit agreements haven't been touched by the new law. Employee non-solicit agreements haven't been touched. So you can still have these employee non-solicit type agreements that says you can't, leave the company and then come back and poach all of our employees for some, similar business or something like that. All right, confidentiality, just mentioning that is now addressed by the new law. And so I think in general, they're not really going to be affected too much. It's just the only thing is that there's this new piece of it that says it's got to be limited to exclude information arising from the worker's general training, knowledge, skill, and experience, and information that's readily attainable by the public. But again, it was always hard to enforce that type of information anyway. So if it was public information, you couldn't really protect it as confidential information previously either. So I think those are generally ineffective, but I do think that confidentiality agreements are going to become more important for employers to have and to enter into with employees, given that now they won't be able to have non-competes and potentially non-solicit agreements for certain employees, especially if they're lower wage employees. Next one, obviously the notice provisions. That's again the biggest thing, easily overlooked, and it's going to apply to all employers who have Colorado employees. So I think that's going to be a very important thing to put into your process for hiring if you do use non-compete agreements. Civil and criminal penalties, we just went over that. Those are important. You want to make sure that you avoid entering into invalid non-compete agreements because of these penalties that are out there. The not retroactive. So that's one thing I should have pointed out probably from the beginning is that this law was signed and became effective August 10th, 2022. But the act specifically says that this act applies to covenants not to compete entered into or renewed on or after the applicable effective date of this act. And so really what this means is that the restrictive covenants entered into before August 10th, 2022 are going to be evaluated under the old statutory and common law framework. So we'll have the old law governing those agreements that you've already entered into. But remember that this is going to apply to any renewal. If you have any renewal type agreement or anything like that changes with the employee, then you're automatically under the new law at that point. So that's an important thing to know. And also the other thing I think that is that I'm wondering, and some other commentators have expressed that they don't think that the retroactivity necessarily applies to the choice of law and choice of forum provision. So I think again, for multi-state employers, it's probably going to be better to change to Colorado law and Colorado forum, because I have a feeling that that's going to be considered a public policy issue that Colorado courts have more of from a public policy perspective, have a more vested interest in protecting its citizens and employees that work in Colorado, and are going to apply the Colorado and Colorado law and choice of and Colorado forum provisions. So I think that's going to probably be something that multi-state employers should look at now, even if the agreement was signed prior to August 10th. All right, and then the other takeaway is review your existing agreements and train. You're going to have to review what you have now, see if you think it's enforceable. We're here to consult on these sort of issues if it's something that you need us to take a look at. But that's certainly, I think, an important piece of this is to start looking at existing agreements that you have and training for the future. So any new employees that are coming in, you got to make sure you're complying with the notice provisions and that what you're actually entering into is enforceable under the new Colorado law. So that's it for this presentation. It's 12:45, so that's about where I thought we might end, and wanted to leave it open for questions. Let's see if there's anything else in the chat. Let's see here. How does this affect current employees with non-compete agreements? Do we have to go back and adjust their agreements to meet current requirements? Okay, so I think that probably came in right before I got into the retroactive piece. So no, you don't have to, unless that current employee has a renewal or has a new agreement or something like that comes up, then you don't need to change. It would be evaluated under the old law. So if it was enforceable under the old law, that should remain. And so you don't have to go back and necessarily adjust their agreement. In fact, if you do adjust their agreement, then you're all of a sudden now under the new law. It may be something that you want to do anyway, honestly, to avoid any issues down the road or potential claims down the road, or people not understanding the non-retroactivity and having an issue with it. But I think either way, you want to take a look at your current forms and make sure that that going forward they comply. But no, you don't have to go back and adjust current employees that have non-compete agreements. As long as they complied and were enforceable under the old law, they should remain enforceable. This new law only applies to those that are entered into after August 10th, 2022, or renewed after that date. All right. Thanks, Jim, for joining. Does anybody else have any questions out there? All right. Well, feel free to send. I think I have my email right there on the slide. Feel free to send me an email if a question comes up later. Happy to answer any questions or talk through any of these issues. Appreciate all the people I see out here. Teresa, thanks for joining. Jim, Danielle, Kyle, Mike, thanks for joining. Appreciate it. And I think we'll probably cut it off here then. And like I said, if you have any questions, just send me an email and we can answer it that way too. Thanks.